Hello, everyone. Welcome to the latest in a series of Keating Chambers webinars covering adjudication, practice and procedure. I'm Thomas Saunders. I'm joined today by Wen-Jin Te, and we're going to be talking about challenges to adjudicators and their decisions on the basis that they lack jurisdiction. And we're going to be covering three broad topics under that heading. Firstly, the role and nature of jurisdictional challenges. Secondly, some common jurisdictional challenges. And finally, questions of procedure, waiver, and reservation of rights. Starting then with the first of those topics, the question of the importance and role of jurisdictional challenges. What's necessary to understand in this context is that the purpose of adjudication, as was discussed in the first webinar in this series, is to provide temporarily binding decisions which the courts will enforce with very few exceptions, regardless of whether or not they are correct. What that means is that it's not open to a party to an adjudication to go to court afterwards and say, well, the adjudicator simply got it wrong, so I'm not going to comply with the decision. And in almost all cases, there are only two categories of challenge which a party might successfully mount to the enforcement of an adjudicator's decision. The first is jurisdictional challenges, which is the subject of this webinar, and the second is natural justice challenges, which will be the subject of a future webinar. And so the importance of understanding what is and is not a jurisdictional challenge goes directly to the question of whether enforcement can or cannot successfully be resisted. In order to understand what might give rise to a challenge, it's necessary to consider the basis of adjudication. Now, it is a statutory right provided for by the Housing Grants, Construction and Regeneration Act 1996, which is then given effect to by contractual provisions, either express or implied. So as you see on the slide there, section 108(2) of the Act requires a construction contract to contain adjudication provisions in writing, and sections 108(5) and 114(4) taken together have the effect that if a construction contract does not contain a valid adjudication procedure, the provisions of the scheme for construction contracts will take effect as express or implied terms. And that was what led Lord Justice Jackson to say in the Grove Developments case that in the ultimate result, the parties have agreed, albeit under statutory compulsion, that the adjudicator should have jurisdiction to deal with disputes between them. And so the statute and the contract, whether that's an express contractual provision or the scheme, both create the jurisdiction of the adjudicator and confine it. The parties have agreed, albeit under compulsion, that particular disputes can be submitted to a person who has been appointed in a particular manner to be determined in accordance with a particular process. And a jurisdictional objection will or may arise where some step in that process has broken down sufficiently for one party to say, this is not a decision which I agreed to abide by. And what that means is that the most common types of jurisdictional challenge generally fall into one of four categories. The first is that there is no adjudication provision at all, and that will only arise in circumstances where what you have is a contract which is outside the scope of the Act, for example, because it concerns operations which are not construction operations or is otherwise expressly excluded from the Act. The second category of challenge arises where the subject matter of the adjudication or of the attempted adjudication is, for whatever reason, not capable of being adjudicated. The third category is where the appointment process, the actual appointment of the adjudicator in the first place, has broken down or been misapplied. And finally, there are challenges which arise where the decision-making process following the appointment has broken down or been misapplied.
Thank you, Thomas. I'm now going to talk through some of the categories of common jurisdictional challenge. The first is subject matter. So as Thomas says, this category involves a scenario where the subject matter itself is not capable of being adjudicated. One example of this category was already discussed in the first installment in this series, and that's where a dispute has yet to crystallize. So, in other words, it's not been established that the parties actually have a difference in opinion as to the subject matter being referred. In that instance, the matter cannot be adjudicated on. Another common example of this category is where the matter being referred was the subject of a previous adjudicator's decision. And this is simply a natural consequence of the principle that adjudicators' decisions are binding until finally decided. Naturally, then, a second adjudicator has no jurisdiction to look at matters that a first adjudicator has already decided on. The emphasis on this point is that the emphasis is on what the first adjudicator decided, not the dispute that was actually referred to him or her. And I've put on this slide a quote from Lord Justice Jackson in Harding and Pace to that effect. Ultimately, it is what the first adjudicator decided, which determines how much or how little remains available for consideration by the second adjudicator. Now, in most cases, what was referred is going to overlap entirely with what was decided. But the distinction is important because that's not always the case. So in Hitachi Zosen and John Sisk, what happened was the first adjudicator had been referred an interim account dispute, which involved the valuation of various items, including an alleged instruction to accelerate, which was titled Event 1176. The adjudicator in his decision found he didn't have sufficient detail before him to give any value to event 1176. And so the figure that he put in his decision was simply nil. The contractor then, in the next interim payment cycle, brought another adjudication before a second adjudicator. And this second adjudication included a request for the second adjudicator to value event 1176. On the employer's jurisdictional challenge, the court found that the second adjudicator did in fact have jurisdiction to decide this point. The nil figure put in the first adjudicator's decision was not a decision as such. It was simply a consequence of his finding that he had insufficient detail before him to make any decision at all. And indeed, the first adjudicator had gone to some length to make that plain in his award. So moving on then to the second category of common jurisdictional challenges. This is where something has gone wrong with the appointment process for the adjudicator. A very common trip-up is found in the process set out within the statutory scheme. You'll see on the slide that I've quoted from paragraph 2, subsection 1 of part 1 of the scheme, which starts off following the giving of a notice of adjudication and then goes into some detail as to the procedural steps required for the nomination of an adjudicator. This is the opposite of many contractual adjudication procedures, which normally allow for the nomination of the adjudicator to take place first before the notice is first issued. So it's important that when the applicable scheme is the statutory one, parties take care to ensure that the notice of adjudication is first served before any steps are taken for the adjudicator to be nominated. In the case of IDE Contracting Limited, what happened was the adjudicator had been appointed prior to the notice of adjudication, and it was therefore found by the court that because the appointment process was flawed, the adjudicator lacked the necessary jurisdiction, and therefore his decision was not enforced. I'm going to hand over now to Thomas for him to discuss the final category of common jurisdictional challenges.
Thank you, Wen-Jin. The final category of common jurisdictional challenges is jurisdictional challenges which arise as a result of the way that the decision-making process itself has been conducted and carried out. And the important distinction between this and the other categories of common jurisdictional challenge is that whereas the other categories are generally matters which arise at the very beginning of the process, so that it might be said that the adjudication is tainted from the start. For example, if the dispute is not capable of being adjudicated or the adjudicator has not been properly appointed. The final category is after the fact, and it involves primarily looking at what the adjudicator has in fact done in the context of his or her appointment. And the most common such challenge is a complaint that the adjudicator has not in fact decided the particular dispute which was actually referred to him or to her, but has instead decided a different question, which is not the question which was asked. So, for example, if the claim which was made by the referring party was a claim simply for a notified sum, but the adjudicator purported to make a decision as to the true value of the works, that would be a decision which was outside the jurisdiction of the adjudicator to come to, and so it would not be a valid decision because that dispute was never referred. Now, the courts are fairly clear that when it comes to looking at this, one has to take a commonsensical rather than an overly legalistic view. But still, it is necessary to determine what, on a fair reading of the relevant documents, was the dispute which the adjudicator was asked to decide. What was the question? So that it can then be seen whether the adjudicator has answered the right question. And the most important document for those purposes is the notice of intention to refer a dispute to adjudication. That is the very first document in the process. It may be possible in certain circumstances, if the notice of intention to refer is ambiguous, to say that the referral notice clarifies that ambiguity, but otherwise, subsequent documents do not change the ambit of the dispute as defined by the notice of intention to refer, unless you can say that both parties have expressly or impliedly agreed to expand or alter the adjudicator's jurisdiction during the course of the adjudication. Now, the one key exception to that principle, for obvious policy reasons, is that it is not open to a referring party to draft the notice of adjudication in a clever way, which would exclude the adjudicator's jurisdiction to consider defences. So the adjudicator will always have jurisdiction to consider valid defences to the claim made, but otherwise, the adjudicator's jurisdiction is limited to the dispute as defined by the referring party in the notice of intention to refer. I'll now ask Wen-Jin to take control back of this talk to talk about certain questions of procedure and waiver, both during and following adjudications.
Thank you, Thomas. I'd like to start with waiver. So it's important, if a party wishes to raise jurisdictional objections down the line, for it to ensure that its conduct in the adjudication proceedings is made subject to an express reservation of rights to make a jurisdictional challenge. That's because without such a reservation, participation in the adjudication alone could amount to a waiver by conduct. So in Harris, the defendant had initially objected to the jurisdiction of the adjudicator on the grounds that there was no written contract. However, the defendant then proceeded to take part in the adjudication fully without making any reservation of rights. And this was found in enforcement proceedings to amount to a waiver by conduct. And so Harris was then precluded from challenging the adjudicator's jurisdiction on enforcement. In making such a reservation, parties should strive to make it as specific as possible. Lord Justice Coulson in Bresco observed that the purpose of statutory adjudication would be defeated if a responding party could simply make a very general reservation on jurisdiction at the outset, and then later comb through all of the documents in the adjudication proceeding to come up with some jurisdictional objection just to avoid enforcement of a ruling which it did not like. So in that case of Bresco, it was held by Lord Justice Coulson that a general reservation of that nature may be ineffective if either it is found that the responding party knew of a specific objection at the time but chose not to raise it, or the general reservation is found to have been worded as vaguely as possible in order to keep all possible jurisdictional objections, even ones which may not have been thought of at the time, open to the responding party to make down the line. Finally, just some brief thoughts on the procedure if a responding party should wish to resist enforcement of an adjudicator's decision by means of jurisdictional challenge. There are really two options open to the party here. Either you could wait for the referring party to begin enforcement proceedings in the TCC and then raise your jurisdictional challenge as a defense in the enforcement hearing, or for parties who perhaps wish to get ahead of any potential enforcement proceedings, it's also possible to start a Part 8 application to seek a declaration on the status of the adjudicator's jurisdiction. It could be preferable to some responding parties who would like certainty as to where they stand in respect of an adjudicator's decision, but it could also lead to wasted costs if, for whatever reason, the referring party opts not to enforce. So that was a very quick tour of jurisdictional challenges, their nature, some common examples of the different categories, and the procedure required if a party wishes to raise them. There will be other talks in this series on various other aspects of adjudication, which we hope you will listen in.